right. So I'm going to say it again. I'm pretty sure you're the most handsome guest we've ever had. And you said what?
You say that to all the boys.
I actually don't. I actually don't. But now I've got to stand by it. So I'll just let everyone know when they come on.
Okay.
Pat, thanks for joining me. I really appreciate it.
My pleasure.
The reason I really wanted to have you on is because for one, I love your energy. I love the way you deal in your business when it comes to real estate law business. I mean, I would trust you. You've been there for me. You've been there for my clients. You're just meticulous. I just love the way you work, Patrick. So that's why I wanted to have you here. And I had heard a couple of stories before from you. Those are the ones we need. So it's great to have you here.
Great to be here.
So let's jump into this. And you put this very eloquently when you sent me an email. I think that you call it the rat shit story. So tell me about your rat shit story. I want to hear about that.
Okay, well, the lead really into that, Scott, is one of the things I think a lot of people, it's frustrating, they don't really contact a real estate professional before they engage in a transaction. And that's very perilous.
Right.
And I don't care what kind of transaction, a purchase, a sell, a lease, you have to have representation. You have to have competent representation. And if you don't do it, there's a lot of pitfalls. And the one that I wanted to talk to you about was my famous non-disclosure rat shit case. I got a referral, and a guy bought a home. And after he was in maybe a week, he kept getting sick.
Mm-hmm.
Turns out the place was infested with dead rats and rat shit. And when I mean infested, they had to rip out all the drywall.
Oh my gosh.
Take it all out so they could clean out the studs. It was a $250,000 remediation. And the thing that was sad about it was, not only did he buy a house where it was intentionally concealed, the owner was a contractor, and when there was a showing, like it had been on the market for 5 years, so there were photos from the MLS where you could see the condition of the property over the 5 years, and you could see he was constantly painting it and really keeping it up. But when you went to visit it, he had chickens outside the main living area with the windows open, so he smelled the chicken shit. So he really went out of his way. And it turned out that he had, and this was the thing that amazed me, he talks about competent representation. Everybody tells everybody to get a pest control report. And typically the pest control report is a termite report.
Right.
Well, there's three different types of pest reports. One is the fumigation, that's a separate license. And then the other two really is termites, and the other one is rodent infestation. And in this case, the seller only did the pest. They didn't do the rodent. Our person didn't know to ask. Their agent didn't tell them to do the whole thing. So when I took the deposition of the inspector, I said, well, look, you're looking for termites. Did you see all this rodent infestation? And he said, yeah. I said, why didn't you say something? He said, well, the seller hired me. That wasn't my scope of work. I couldn't make that disclosure because it wasn't part of my job. I said, okay, wait a minute. How much would it have cost for you to give the report for rodents? You ready for this? $50. So that was one of the things, that I always tell people, and a lot of realtors didn't know there's different types of pest control reports.
Right.
I said, so as an adamant part, you always put that in there because, we litigated it probably over a year. The fees were 6 figures. And it was a very adversarial proceeding, which really goes to one of the other reasons you have to have a qualified professional to guide you on this. As you know, the purchase agreements in California, the attorney's fees provision is with the buyer and the seller.
Right.
Not the agents, not the inspectors. Now, in that particular case, as soon as the guy sold his house, he moved to Florida. And that was problematic from not only being out of state, but you can't get a house in Florida, which was his only asset. The guy was kind of a deadbeat contractor.
Right.
So we were left with going against the brokers and the inspectors. who all have insurance defense companies, and they litigate the heck out of it
Right.
to try to grind you down, and no attorney's fees provision because they weren't parties to the contract. So that was a real problem. People don't recognize the non-disclosure, because if your seller doesn't have the old proverbial pot to pee in, you're in for a real arduous time.
Right. Because they'll find someone to come after. So this guy wasn't represented. So there was no home inspection or anything that could have identified.
Well, no, he and I actually gave a presentation on this. He was represented by an agent, and the problem was, did the agent do all the due diligence and disclosures she was supposed to for him? No. And I will tell you, because when it came to me and I found out the seller was gone, I sued the listing agent, I sued the buyer's agent, his agent, and the inspectors. And when we settled it for a nice six-figure number.
Right.
The buyer's agent and the seller's agent each kicked in the same amount of money.
Really? So your contention with them is that they should have known this too.
Well, and just, I don't know if you really want to get to this point, because it was a legal point, because even the insurance companies, that attorneys didn't really see it coming at them. What had happened was, there was after escrow was opened, there was a report that seemed to indicate that there could be a problem. But guess what? The listing agent never did.
Oh, it never did a thorough investigation?
Never. They did the Avid report. Right. And the seller disclosures came in, you got the Avid report, and that was the end of it. But then they got a report from one of the inspectors that highlighted an issue, and the buyer's agent did not advise the buyer as to what that meant, and that he should hire an independent investigation before the close.
Right.
And the agent didn't realize, which was surprising, the duty to disclose goes until the close. Anything you learn during escrow, you have to disclose it, as does the seller.
Right.
The seller didn't do it. And the sellers, they were arguing, hey, it was in the report, so everybody knew. I said, no. I said, where is it in your written disclosures? And they said, what do you mean? I said, great, you got a home inspection report. It was sent out. That's one issue. Where did you meet your statutory disclosure obligations? Right. They went apeshit. That's why we settled them. They thought the fact that was in a home inspection report was sufficient, and it didn't meet their statutory duties of disclosure. So actually a case that says that.
Wow.
And when I presented it to them, they said, what are we supposed to do? You take the report. You say, the report says this, and this is what it means, and you better go find somebody. And nobody did that.
Right. So they should have brought a light to it, is what you're saying. And then was there physically something that the agents should have seen themselves too?
Well, that was another issue that was kind of something that surprised them, because, as you know, a lot of agents, your duty is to inspect everything that's reasonably accessible. And during the course of this case, the agents really took the position they never go to the attic, because as far as they're concerned, it's not accessible. And had you gone in the attic, you would have seen the rodent infestation, because it was an attic with the floor, and the insulation was in the floor, not the roof. Well, here was the problem. It wasn't one of those attics where you have to pull down rickety stairs to go up into it. There was access through a closet through a bedroom. And I said to him, excuse me, do you ever check the attic? No. Why not? Well, no, it's not accessible. I said, well, how about this door? And they said, well, no, we don't go in the attics. And I said, that's your problem. I even think if, let's say, you have an infirmity, you better get somebody on your team to go up and look at the attic if there's access to the attic. Just because you can't, that doesn't mean your team shouldn't be doing it.
So, question: when the inspector was up in the attic, don't they? Because if our inspector's there, they take pictures of each area. If they see a water stain, they see a crack. If they were up there, they would see it. Same with our termite guys. Termite guys looking for wood damage, water damage, looking for rodent, looking for termite, looking for everything, and then they disclose it.
Home inspector never found.
Wow. So,
yeah.
Because you would think that
Yeah.
that there would have been something that was just so blatant for them to see, especially with that kind of smell, and if there's something visual that the agents could have seen, you would have thought.
Well, the most visible was in the
Right.
attic. There was some facial work that they had to do, but it really didn't show you the extent of the rodent infestation. It was more dry rot, that type of a thing, and they replaced it. Nobody, and the only guy who really saw it just kept his mouth shut because he knew if he said something, it would be a
Mhm.
problem. But he wasn't the buyer's inspector; he was the seller's inspector.
Okay, so the one you got the one you saw, but the other guys you're saying it was reasonable that they would have seen it if they went up there, but
Oh, it was visible if they went up
okay,
in the
there we
attic.
go. Okay.
It was visible if you went up in the
All
attic.
right.
So that was kind of the ratchet
Mm-hmm.
story. $50, the guy would have found out about it, and he would have bought the house. I mean, for $50. Um, this is one of my pet topics to talk about. And in the AIR forms and in the CAR forms, they all have one paragraph, two paragraph provisions about mediation
Mm-hmm.
arbitration. Mediation, it's okay because it's non-binding. Arbitration, people don't understand this. And I actually gave a presentation to a brokerage, and the manager started arguing with me, telling me I was
Mm-hmm.
full of it. And I said, if you don't believe me, ask your
Right.
lawyer, okay? Because she didn't like what I was telling her. The problem with the JAMS and the AAA arbitration
Mm-hmm.
provisions, they don't protect your substantive rights. And what that means is when you go to arbitration, it's supposed to be
Mm-hmm.
expedited. So the arbitrator doesn't have to follow the rules of evidence. The evidence he relies on doesn't have to be admissible. The documents don't have to be authenticated to establish what they are. He can accept anything he wants. They don't have to state the reasons for their decision. They don't have to follow the law. Okay? They don't really have procedure to have a record during the proceedings. So if you need to appeal it, you have an adequate record. Those are some major problems with arbitration, the standard arbitration provisions in the CAR and the AIR forms. That if you have a big dispute, and anymore with the average price of a house in LA over $1 million, they're all big disputes. And people don't realize that. The big reason people like to go to arbitration, it's supposed to be cheaper, right? I just finished a case. It went on for 5 years. It was a commercial lease case. My client was chasing $350,000 in back rent. The guy declared constructive eviction, wouldn't move, wouldn't pay the rent. We eventually had to get him out, and we started the lawsuit. 5 years later, it was referred to arbitration because there was an arbitration provision in the lease. I didn't negotiate it. And after doing a month-long arbitration on a $350,000 claim, they just sent us the check last week because they got the judgment $1,150,000. Okay. Now, how did it get that? 350,000 for the rent, 70,000 in back interest because it was a sum certain you're entitled to interest 10% on the date that was due, and it was 4.5 years ago. My attorney's fees, because this was so adversarially done with the other side, $500,000.
Wow. I guess you're buying lunch next time we go out.
Our out-of-pocket costs for depositions, experts, all of that horseshit, $110,000. And here's the kicker: the arbitrator's fees, each side, $220,000.
At what point?
Jam.
This is crazy because I remember you were saying once when we were talking, you said, if unless it's a huge amount of money, you need to not litigate, or you need to not go to court.
Yeah.
What was the amount that you said?
You can't try a case. I can't try a case. Maybe other people can because they don't. But to properly work up a case and get it to trial in Southern California, it's going to cost you at least $150,000. So if you aren't prepared to spend that, don't even start the ball rolling. Because you give me an example again on legal representation. I just got a referral on a guy on a lease. He signed a lease 10 years ago. Didn't have a lawyer, didn't have a broker. It was a guy he knew next door, thought he was a nice guy. He signed the lease. 10 years later, the guy's basically on a 3,000-foot retail space. He gave him a a repair demand at the time he was leaving for $39,000. Now that we're in litigation, the last estimate a year later, he's up to $121,000. And what he's basically trying to get the guy do is give him new premises so he could relet it because he's having trouble reletting this on Ventura Boulevard. And he's overlooking normal wear and tear, the approved use, the fact that he allowed the guy to do all these improvements, never gave him the notice to remove the improvements because he had to do improvements to suit his business. There's all sorts of issues. But now my guy's involved in this litigation because basically the landlord's a real dick. And, for 3,000 feet, he's looking for $40 a foot for remediation.
I've got another question for you. On the mediation arbitration. So what do you advise your average buyer or seller to sign? Just the mediation then, or what is your advice?
The mediation is no harm, no foul. The only problem with the mediation provisions, and I know a lot of people say, well, if you're not going to sign that, that means we're going to get litigation, and there's a lot of pushback, especially from the sellers when you refuse to sign those. The only problem I've had with the mediation was there's no time limit when it has to be completed. And a lot of the agreements say if you don't mediate, you can't get your attorney's fees. And some people play the game where they drag it out and drag it out and drag it out. And it's like, what are you supposed to do? That's the only problem I've seen with mediation. But since it's non-binding, no harm, no foul. It works, it works. It doesn't work, it doesn't. Arbitration, I just tell people, I won't sign an arbitration provision. If the dispute is suitable for arbitration, you can always agree to do it later. You can stay the case. You can go to arbitration, but it really depends on your adversary and the other attorney, and you have to feel comfortable that they're not going to abuse what arbitration is supposed to be in an expedient manner of resolution. The commercial lease case, I said to the guy, I said, look, let's just litigate this. We don't need to go pay for a private judge. And he said, no. I said, well, at least modify the rules. He said, no. 5 years later,
my gosh. You think at some point someone would, you and I talked about a few different cases, and one that I was dealing with at one point, it was like, you know what? This isn't worth the heartache. There's too many ways for it to go south. And at some point you just got to let it go. But this guy didn't even let it go after $1 million is gone.
Well, the problem was his client was listening to him, and he from day one, he gave his client bad advice. And I always said to my client, I said, when this case is all said and done, I said, maybe you should have a conversation with your former tenant and tell him if he wants to sue the attorney for malpractice, be his first witness. He gave him bad advice from day one.
All I can tell you is I would not want to go up against you. You're a nice guy. I think the world of you, but I would not want to get into the boxing ring or into a court with you. I'll just say that. I'll just be very clear.
And I guess this is part of the qualified professional. And even though this is real estate hell with Scott Nell, and I know it's not really within the area of your expertise per se, I had a client who had a unique situation during COVID with a deadbeat client. And you couldn't even file an unlawful detainer action. But in California, there's something called a forcible detainer, which means you illegally obtain possession of the premises. Unlawful means it's usually you stay past the lease or something like that, so you had a legitimate reason to go in. Forcible is when you don't. I filed it in Ventura. And I laid out the facts very carefully because I didn't want the judge ever come back and say, hey, you kind of ambushed me on this or anything. And in the middle of COVID, 3 sheriff's SUVs pulled up and escorted the people in the house because the forcible detainer worked. I mentioned it to Don Manson at one of our meetings, and he looked at me and said, that's never going to work, Pat. And I said, and it did. So that's why, I guess it's like what you do. 100%. Surround yourself with good people. And whatever the cost is going in, it's going to save you money.
Yeah, I totally agree. And I remember you gave me some advice once, you told me when I was getting some advice from you on a situation. You said, okay, Scott, we've talked about this. We've talked about it again. I've given you my advice. If you don't take my advice, stop asking me for any advice on this particular issue because it was to that point. And I listened, that's a good point. That's a good point.
It's sometimes you
Right.
hear what you don't want to hear, and your options aren't the options you want.
So we like to highlight something that's close to your heart, like some type of, is there any type of charity or anything that you would like to share so that we can highlight that?
Sure. I'll start with one thing that's, I typically, one of my attempts to be charitable is I usually take one pro bono case a year where somebody's getting screwed and they can't afford a lawyer. And if it works, I might get paid from the attorney's fees per year we have one. If not, that's okay. But that's been one of the things I've done for 48 years, which I don't think a lot of lawyers do. But, the one, as you well know, is Mercy Child Care for the Ugandan charity that's important to you. And the reason that's become important to me is because I've gotten to know you. But more importantly, I see the joy it's brought you and your family and your daughter. And it warms the cockles of my heart. And if it did that for you and I can help somebody else, or I even help you help somebody else do it, it's been really rewarding. And I've enjoyed it. So it's been, because it's so personal to you.
I appreciate you saying that, because you've gone out of your way. I won't go into the whole story, but you went out of your way to challenge some people to give more. And those efforts ended up raising, within just like that short a time, it was over $5,000 for Mercy Child Care. And as you know, it's important to me because, our daughter is just amazing. She came home from Uganda about 12 years ago, and we can't imagine our lives without her. I mean, she's amazing. And it was Mercy Childcare and the people over there that made the introduction and facilitated the process and changed our lives and the lives of generations to come forever, because our daughter came home. So
that answered all the questions about a charitable gift for me. That is my money really going to go somewhere where it's going to do something worthwhile and effective? And obviously the answer was yes. And just as a reminder,
I love it. When you say you want to get something done, you get something done. And the truth is, when I was over there, I remember how just like the little money that was had there, or we brought cell phones that they would sell, and to support, and the way it was putting kids through school. There was a kid that was sick that really would have taken like $100 or $200 to keep this kid from dying, and they didn't have it. And so this is where all of this money came, helped this child. I mean, it helped they built a school, they built a medical clinic. It's just amazing. I could go on forever, and I won't, because it's not about me, but thank you for your heart for that. Really appreciate it.